afternoon. I'm Julia Peng, Senior Associate at Cotchett, Pitre, and McCarthy. Welcome to Encountering Difficult or Deceptive Clients. What are my options? This event is hosted by the Education Committee and is eligible for 1 hour of California Ethics MCLE credit. This event is recorded and will be made available to all registered attendees. Please sign in for this event by clicking the link. You will also find links to the written materials, an evaluation form, and the event registration form. Only registered attendees will receive their certificates of attendance. So if you have not registered yet, please do so. Our panelists have kindly put together the written materials for this event, including the 4 hypos that will be foundational to our discussion today. So please have those materials handy. There will be time for Q&A at the end, and our speakers have kindly agreed to stay an extra 10 minutes if needed. Now, I'm honored to introduce our 3 panelists who have all spent a ton of time preparing for this event. Aria E., or Aria with the cool last name, serves as Executive Director to Maine's Board of Overseers of the Bar. Her primary responsibilities include administering the board's financial and regulatory systems, advising lawyers on ethical concerns, and presenting continuing legal education programs. Aria gives lawyers guidance on the rules of professional conduct, and she investigates and prosecutes cases involving alleged violations of those rules. Aria also teaches professional responsibility at Maine Law. Bill Munoz works for himself as a third-party neutral at Munoz Dispute Resolution. Prior to starting his own company, he was a civil trial attorney for over 20 years, focusing primarily on the defense of professionals, including attorneys. Bill is a certified specialist in legal malpractice law and was recently appointed to the California State Bar Committee on Professional Responsibility and Conduct. He also serves as an expert witness on standard of care and ethical issues in legal malpractice cases in his spare time. He was previously the chair of the California State Bar's Legal Malpractice Law Advisory Commission. And now Dan Sharp is a senior counsel in Crowell & Morin's San Francisco office and a longtime member of the firm's Professional Responsibility Committee. Dan practices in trial and appellate courts and arbitration in several fields, including professional responsibility, university affairs, real estate, corporate control disputes, and the representation of individual investors, corporate officers, and directors. Now, Dan, can you walk us through the basics of the attorney-client relationship and some best practices to consider before we dive into our hypos today? Dan, you're muted.
Thank you, Julia. Before we get into specific hypotheticals and situations, in thinking about how to comply with ethical obligations when dealing with problem clients, it's helpful to focus and get a clear understanding on what the attorney-client relationship is and how the rules of professional responsibility go about regulating that relationship. The attorney-client relationship has three primary aspects. The first is that it is a contractual relationship, except for situations where the attorney is appointed by a court. The relationship of attorney and client is formed by a contract, which means all the elements of a contract, agreement, and subject matter. The contract can be expressed, it can be implied from the circumstances, but it is nevertheless a contractual arrangement. And it's a contract. The second aspect of it is a contract to form a relationship of principal and agent, in which the client is the principal and the attorney is the agent. And the third aspect of it is it's a special kind of agency, which is a fiduciary agency, because as a attorney, as a person of greater skill, understanding, et cetera, the attorney occupies a fiduciary relationship to the client. Now, the rules of professional conduct in California and elsewhere provide rules that regulate the relationship of attorney and client and impose certain obligations on attorneys when they are in that relationship. And it's customary to speak of these rules as ethical rules and to speak of this topic as legal ethics. And that's really something of a misnomer, and can be a little bit misleading, because ethics, strictly speaking, is a branch of philosophy dealing with the difference between right and wrong, and figuring out what in the world is right versus what is wrong. It's also known as morality. And it's a common or hackneyed phrase that lawyers don't legislate morality, or courts don't legislate morality. And the rules of professional conduct don't attempt to do that either. What they do is they regulate the relationship of attorney and client, and they decide what's right and wrong, or set out the guardrails of what's right and wrong in the conduct of that relationship, in the process of that relationship. The rules could have, we could have had a system where the lawyers had a true ethical duty to advance justice, or prevent injustice, or observe some kind of standard. But under the rules of professional responsibility, the lawyer's role is to advance the objectives of the client, and the client sets the objectives. So in terms of true ethics, true difference of right and wrong, what moral conduct is, the extent that that's implicated by the rules of professional conduct, and for lawyers, it's in the choice of client, in choosing which clients you represent, and how to spend your professional energies. Because the client is the principal under, this is found in ABA Rule 1.2 and California Rule of Professional Conduct 1.2. The client sets the objectives of the engagement, and it's the lawyer's responsibility to carry out those, or achieve those objectives within the bounds of the procedures applied by the substantive law of the area. So with that framework, there is obviously best practices and things that lawyers can do to avoid taking on clients who will prove to be difficult and deceptive, or and so forth. Our program here today, assumes that the client is already in the door, and this is someone that you're already dealing with. But we by no means mean to discount that there are best practices to be observed in the intake of clients. Having careful intake procedures to avoid, red flag clients, the people who have gone through multiple lawyers on the same matter, or who appear to be difficult personalities. And there's best practices around the crafting of engagement letters, setting forth the contractual terms of the lawyer-client relationship, and placing responsibilities on the client to meet certain responsibilities to carry out the engagement. Those things are beyond the scope of our talk here today, but wanted to set that framework and go from there.
Just follow up with you, Dan, on that. I know it's a little outside the scope, but I think one thing important for best practices, especially for purposes of our topic, is when you have the engagement letter, include a provision in that engagement letter that requires the client to cooperate and to be honest and forthright with you throughout the representation, because that can, if things do go south and they run into clients that we're going to be talking about here today, that can form a basis for a motion to withdraw if need be down the road under Rule 1.16B. So something to keep in mind in your engagement letters as well.
It's also, I'd like to jump in here too. When you're first meeting with a client, you're trying each other out. And so one of our retired lawyers here in Maine said, "I never regretted the client I failed to take," which is so true for any of us who've had at least some, if not a lot of difficult clients, depending on your practice areas. That's absolutely true. And it's important in those first couple of client meetings to manage expectations. Here's what I expect from you. Here's what you can expect from me. I have a set of rules that govern my conduct. And I want you to know that my decisions will be informed by those rules. and I expect you to cooperate with me from everything spanning communicate with me, keep me apprised of your contact information. And also, if there's times that, as we'll talk about in the diminished capacity realm, that I might need to have you give advanced consent to some of the decisions that need to be made. But that would be for a specific client. But really laying out those expectations so that you're not scrambling in the middle of a difficult client situation, and you're hostage to that situation.
Yeah, if the hairs on the back of your neck are going up when you're having these conversations with the client and they're giving you pushback on things that you're saying, that ought to be a red flag to you. That's probably not the client that you want to take on. So just some things to keep in mind. With that, why don't we dive into the topics that we're here for today? What we're going to be talking about are difficult clients, clients who have diminished capacity, and then talking about deceptive or dishonest clients. And throughout, we'll be weaving, we'll have hypotheticals that you all been provided, and weaving the rules and best practices into those discussions as we go through the hypotheticals in each of the types of clients that we'll be talking about. And with that, Dan, why don't you tell us a little bit about difficult clients and how to handle them?
Well, let's take up the first hypothetical. This is dealing with a corporate client. As we've laid out in the hypothetical, we imagine a privately held company, probative corporation that has a board of directors with 4 members, all family members. The father's the chairman. 3 daughters are also directors, and they're the officers of the company running it and overseeing its 100 employees. And they have a situation where they believe the company has a claim against 2 former employees who may have stolen trade secrets. The chairman reaches out to a lawyer that he knows at a big firm, and that lawyer, Drucker, does not have the right experience, but he hooks up Edward, the chairman, with a partner and an associate with the right background, and they come up with a strategy of bringing a lawsuit and a preliminary injunction, and coming out full guns a-blazing on this potential claim. And Edward and Barbara, the 2 of the directors, think it's a good idea, and the other 2, including the woman who's the CEO, don't think it's such a good idea. And what should the lawyers do? This Mitchell, the partner who's in charge of the matter, confronted with clients who can't come to an agreement on how to proceed. Let me turn that over to Bill and Aria to comment on that particular scenario, and we can discuss that.
Yeah, I think the first issue is, who's the client? If the corporation is the client, then you have half of the directors who are on the board for the action to be taken, and 2 not for the action taken. That's a situation where, who else can you go to above and beyond to maybe break the stalemate would be one, if there is some such person. If not, then I think the best approach there may be to have them all sit down, and you as a lawyer explain to all of them what the proposed action is. Why are you proposing this action? What you seek to gain from such reaction or action, and hopefully that will maybe assuage any concerns that the 2 who are not in favor of the action, maybe that'll assuage any concerns that they may have, such that they are on board, or at least one of them's on board, so you have a majority of the board who is agreeable to such an approach. That would be one thought.
That's exactly right. The issue that you identified at the front, Bill, is the key one. Who is the lawyer's client? And we've included in your materials Rule 1.13 from the California Rules of Professional Conduct dealing with organizational clients, entity clients. And the client is the entity itself, the corporation itself, separate from its shareholders and officers and directors. The client is the entity itself acting through its highest authorized representative. And so the question then becomes, well, who's the highest authorized representative here? You've got Edward, who's the chairman of the board, but you've got Wilma, who's the chief executive officer, and you've got a board that can only act as a board with a quorum present. So these are issues of corporate governance that are a bit beyond our topic here, but the approach that Bill has suggested is the path forward, where you have a decision-making body that consists of more than one client representative that is deadlocked. Your approach as a lawyer is to seek to achieve consensus so that the entity itself makes a decision through its governing processes that the lawyer can act on. And if you can't get that out of the corporate governance process, the lawyer doesn't have a client that can act because the board is deadlocked. And in that situation, the lawyer's responsibility would be to step aside, the lawyer for the corporation, because a lawyer for a corporate entity cannot take sides in shareholder disputes or officer disputes over who is the rightful decision maker for the corporation. So that's a difficult client situation that involves corporate governance rules. It's one where a good engagement letter at the outset could solve this issue by identifying who the lawyer's client representative will be, who the lawyer will be entitled to rely on for decision making, and spell it out in advance so that when these hard decisions come up, all parties will be have an agreed upon procedure for proceeding. Any further?
Dan, in that situation, Dan, just a quick question. Would that be a situation where you, as the lawyer who's coming on board, would you want to see the governing documents to make sure that, yeah, you want to have a majority of the board, or is there something in those governing documents that would indicate the CEO is the spokesperson, or something along those lines?
Well, like I say, ideally you'd spell it out in your engagement letter, and you wouldn't need to see the governing documents to have a procedural setup that is workable for everybody. You look at the governing documents when a dispute arises. For example, in this hypothetical where you've got now a deadlocked board, you need to know, does the chairman have the authority to hire and fire outside counsel, or is that the CEO? And that's an issue that's going to be addressed, if at all, in the company's bylaws and organizational documents, or in their past practice. And a good engagement letter would avoid having to go through that, and we just have a contractual agreement between the lawyer and the company, and this is how this engagement is going to work.
Gotcha. And assuming then that the lawsuit does get filed after much dispute and internal debate within the company, then what would be the next steps?
Well, I think the next step would be identifying the process by which the company is going to make decisions in how to handle the litigation, whether to file, whether to settle, those substantive decisions. This initial deadlock, the resolution of that will resolve how future decisions get resolved as well. And the push comes to shove, there are corporate remedies like appointing a provisional director for the board to break deadlocks that could be resorted to. But the point here is, in dealing with organizational clients, organizations can be difficult when they have internal disagreements and when there's not clear authority to direct the attorney in handling matters for which the attorney is engaged. So let's turn to, unless there are other on that, let's turn to the second element of this hypothetical, which deals with discovery and inspection demands. And when the litigation's filed, the other side asks for discovery. And Nancy, who is the company's chief operating officer and one who might have a lot of interesting emails about the company's operations, drags her feet and doesn't want to provide access to her computer, and is not cooperative in providing her computer so that it can be searched and documents produced for discovery. How should the lawyers handle a client, or in this case, a client representative who is not cooperative in providing documents and doing things that are required of the legal process? Throw that open to you and Aria, Bill and Aria.
Yeah, I think having dealt with that situation in my own practice, not necessarily with a corporate entity, but just with clients in general, I think you as a lawyer have to let the client know that, we have to produce all these responsive documents. They're relevant to our claims going forward, and identify the importance of those documents. And at the same time, let the representative know that if, the other side may have copies of these emails that you don't want to produce, and then maybe they're not going to be good for you. But if they have them and we don't produce them, that could lead to some adverse consequences down the road, vis-a-vis a motion to compel. And if they're not produced, then the implications of that in terms of sanctions, vis-a-vis monetary sanctions, or if they, the client just continues to refuse to produce documents that that they're in their possession and are responsive, you got issue sanctions, and then the worst case scenario is terminating sanctions. So you as a lawyer have to lay that out for this representative. And if the representative is still non-responsive, then you have to go to the next level up. I mean, maybe someone else on the board, maybe the CFO or CEO, whoever the case may be, to encourage that representative to produce these documents. That's been my experience. Is sometimes you got to go over someone's head to do that. And you want to ensure them, certainly when you're talking about electronic documents, the security of maybe getting an expert who can preserve the confidentiality or any privacy issues that you may have. And I'll obviously let the client know that, hey, if we're going to have to get an expert to help us with this document production, it falls within the ambit of the attorney-client privilege. So anything we tell this person, it's going to be still under the veil of the attorney-client privilege. So you don't have any concern about leaking confidential information or giving information that shouldn't otherwise be given.
And this is one of the reasons that we talked about in the beginning of making certain to lay out what the client's rights and responsibilities are in the representation. Here's going back to our comments a little while ago. This is what I'm required to do for you, and this is what you're required to do as part of your contractual relationship with me. And when clients have not followed, at least in Maine, and when I've spoken on this topic before, when clients are not following their lawyer's advice and they refuse, and the lawyer gives as Bill has laid out, the lawyer gives the client the rundown of the consequences and the pros and cons of the client failing to be responsive, client still refuses, then the lawyer has a decision to make whether or not to stay in the representation. And it may be that the lawyer's ethical obligations under the prevailing rules of conduct require the lawyer to move to withdraw, or if there's no tribunal involved, to terminate the relationship.
Exactly. And that's you put your finger, Aria, on where the rubber meets the road. One of the things that I learned coming up as a lawyer is you don't tell clients they can't do this or they can't do that. You tell them, if you do that, this will be the consequence, and you can expect these consequences if you do that. And if you refuse to produce documents that are required in discovery, or if you refuse to make your computer available for inspection, the consequences will be sanctions, they're terminating sanctions, and potentially if the lawyer cannot condone the client's conduct, the lawyer's remedy is to withdraw from the representation. And the rule with respect to that is Rule 1.16, which would not necessarily require the lawyer to withdraw, even where the client is taking a position that is sanctionable and not supported by a good faith argument for modification or reversal of existing law. The lawyer is not required to withdraw, but it's certainly a permitted action for the lawyer at that point. And if you're in a case that's before a tribunal, you have to get the tribunal's permission to withdraw, and otherwise to avoid prejudice to the client that is avoidable prejudice.
Yeah,
Dan, if I can, go ahead, Bill. Then I'll come back to mine.
I was just going to say, Rule 3.4 also is implicated in this particular scenario, because you as a lawyer have to exhibit fairness to the opposing party and counsel, and that means that you cannot, prevent another party from getting relevant evidence. If you have it in your possession, or your client has it in his or her possession, and you know that they have it, you can't basically counsel or assist that client to not give that information or not produce those relevant documents, absent some privilege, of course. But so you have to think of that in terms of that rule as well. And the other point I would add too is when you start to deal with this situation where you're getting pushback from the client in this instance, the documents, this is something you obviously want to have a conversation with the client about, but you also want to document it in writing. This is what you've asked for. You've refused to produce it. This is why you should or need to produce it, and the consequences therefore. And this is particularly true when, usually dealing with discovery. In most firms, it's partner associates, maybe senior associates. And it's usually the lower level attorneys that are doing the day-to-day discovery. And they may have a little resistance to maybe push back on the client. And in that situation, you as the junior attorney want to talk to the partner who may have the relationship with the client, who can then speak to the client about the issue as well. So you as the young associate aren't stuck in between a rock and a hard place wondering what you should do. In that situation, you ought to seek help from the partner.
Right. And I want to just jump in. You were going exactly where I was going, Bill. Even though I'm the executive director now and I no longer investigate and prosecute claims against lawyers, I did that for about 15 years in my role as deputy bar counsel and then bar counsel here in Maine. And I'm very cynical about what happens to my colleagues, having had difficult clients when I was a solo practitioner. As soon as something goes south, they're filing complaints against you. So you absolutely want to document, as Bill has indicated. But before that, you were talking about Rule 3.4, and a lot of the complaints that we see in Maine are from adverse parties. Bill didn't do what he needed to do to make sure that Bill obstructed discovery processes. Here's the order, and Bill didn't make his client do it, or Bill assisted his client in failing to produce discovery. Bill knows that's not true. His client knows that's not true. But Bill still has to defend against the bar complaint that the adverse party filed, or probably more tricky if opposing counsel files it, because it comes with a little bit more credibility oftentimes when it's another colleague. And so life's too short to go down those roads. And I never counsel lawyers when I've given them advice on the ethics helpline to stick their necks out for the client who won't cooperate. And there's just nothing to be gained in that, even for the high money client. And that my second point is what you addressed, Bill. If you have no power or leverage in the firm or in the legal office, and you're stuck trying to manage that client on your own, it's very difficult. And so for those of you who are managers of subordinate lawyers or ethics counsel or general counsel in your firms, be thinking about how your clients are treating the lower level attorneys in your firm and make certain that you're giving them support for some of these difficult clients. Please.
Good advice. Good advice about documenting the conversations with the client. It will not necessarily be usable in the withdrawal motion. There's a tension between Rule 3.4 that Bill and Aria were just discussing, which is the rule that requires a lawyer to not obstruct the other side's access to evidence and to basically be fair in litigation, with the lawyer's duty of confidentiality to the client. And in withdrawing from a representation where there's been this sort of breakdown, the lawyer still has to maintain the duty of confidentiality to the client and cannot do what in the inside baseball or the inside lingo is a noisy withdrawal, where in withdrawing from representing a client, the lawyer reveals the client's dirty laundry or the reasons that would be embarrassing to the client that are otherwise confidential. So that's a tension that can arise in these situations.
Dan, can I ask you this? I don't know how much this comes up in California, but is it fairly? Well, I'll just ask the question. How often does the tribunal not allow lawyers, in your collective experiences, Julia, Dan, and Bill, not allow lawyers to withdraw when it's clear that the lawyer's having this difficult kind of relationship with clients?
It's relatively rare, and the situation where I have seen it, and it's only been a couple of times in the 35 years I've been practicing, are situations where the case is very close to trial and relieving defense counsel of his representation would disrupt the court's docket, prevent the case from going to trial, and in that it would fall within the can't avoid prejudice rationale for denying the motion.
Yeah, that's right. That's been my experience too. It's usually up against a trial date, or you'll see my hypothetical a little later where you're at trial. The prejudice against the client, absent some agreement by the other party for a continuance, whether it's a pending motion for summary judgment or some other type of dispositive motion, it's more likely than not that the court will not allow you to withdraw, even if it's. I mean, I would argue probably even if it was mandatory.
Right.
So.
Right. I mean, I hear from lawyers more and more here, and it may be. I think it's because courts don't want or trying to limit the amount of self-represented people, particularly self-represented difficult litigants. The last thing that the court wants is those folks to not have counsel. And if Dan or Bill or Julia didn't get out in time in that great window, before you got too close to a deadline, then the court's going to leave you in the representation, even if the client fires you. And so it would be a mandatory withdrawal or some other reason. And that's just, I'm seeing that as a burgeoning problem here. At least I'm hearing from lawyers that they're being stuck in cases with difficult clients. And I have to think that some of it is just in order for the court to manage the cases a little bit better.
Well, to keep us on time, speaking of your hypothetical, Bill, why don't we turn to that now?
You're muted, Bill.
You're muted.
Sorry about that. I had two hypotheticals that I presented, but I'm going to focus on the second one just for purposes of time here. And that was the situation. This is a real life situation that I was actually a part of, on the good side of it, though, mind you, involving Cindy when she was at the restaurant and was a patron of the restaurant. And one of the servers walks by and drops a tray of glasses, and some of the glass gets on the table and allegedly in Cindy's eye. And so she went to the emergency room. They did find a couple shards of glass in her eye, removed it. Eye was otherwise fine. Both eyes were fine. Cindy sues the Lucky's restaurant and goes through two attorneys. The second attorney, neither attorney really did much in the way of discovery. I, as a diligent defense lawyer, did all the discovery that I needed to do because the lawyer's name was Bill, i.e. me. Taking depositions, taking the plaintiff's deposition, getting all the medical records, getting an IME to address this issue of whether or not she was actually blind. As part of my diligence, I got sub rosa conducted on Cindy, which indicated, contrary to her deposition testimony, that she was in fact blind. She was walking without assistance, didn't have a cane, anything of that nature. And so this was not too far before trial. So it wasn't something that I just had for a year and decided to hold it. This was right up towards the end of trial or close to trial. Get to trial, the first day of trial, we're meeting with the judge, doing the motions in limine, exchanging witness lists and exhibit lists and the actual exhibits. Part of my exhibits was the sub rosa surveillance. And one of my witnesses was the person who conducted the surveillance, so I could obviously authenticate the video. And that was, midway through the first day. We broke, and we're going to come back and pick a jury the second day. Second day comes, I'm there early. Opposing counsel comes and says, I need to speak with the judge in camera before we start today. And at that point in time, Bill, the lawyer, thought that there was an issue because of what was in that surveillance video. Kane, the lawyer, intimated as much, and because he indicated he had a conflict that he needed to talk to the judge about. Now, in that situation, presumptively, it was Kane confronting his client with this idea that here you are claiming in this lawsuit and have been claiming for the last couple of years that you were blind. The medical records don't support it. The IME doesn't support it. And the surveillance video doesn't support it, yet she still wants to press forward with the case saying that she's blind. I mean, in that situation, what can Kane do as the lawyer at that point in the second day of trial? Aria, Dan, any thoughts?
Well, obviously, Kane, I would assume that Kane is aware that he's got a meritorious claims problem. And now he's been, fraudulently used by the client. His services have been fraudulently used. It's the concern we were just talking about. Maybe the court's going to let him out. It's hard to believe the court would. The court may let him, in that instance, if there were another jurist available that wasn't the trial juror, it might be able, Kane might be able to be candid about what's going on with the client and make his pitch to get out so he's not stuck in it. And the non-presiding jurist hears the whole shebang in camera and lets Kane out, and she's on her own. What's her name? Candy?
Cindy.
Cindy's on her own. But those are just some things that jump right out. Dan?
It's I'm just looking at Rule 1.16 on withdrawal from representation, and it's divided into situations for mandatory withdrawal or permissive withdrawal. And in the mandatory withdrawal only applies if the client is pursuing a unmeritorious action for harassment or the purpose of harassing or maliciously injuring another person. If it's merely a situation where the client is pursuing an unfounded claim or a criminal or fraudulent course of conduct, this is Rule 1.16b, then withdrawal is only permissive. And so the lawyer has to walk the fine line between not suborning perjury or presenting perjured testimony and representing the client within the bounds of the law. So you're right. The lawyer can make a motion to withdraw, but if it's denied, the lawyer may be in a situation of proceeding to trial with a client that the lawyer does not believe is credible or actually believes may be lying, and in which case the lawyer could not call that elicit such testimony from the witness on the stand.
Right, and I think there's a case that I came across when I was prepping for the session that really kind of talked to this particular point at this stage, kind of in litigation. It's a case called People versus Riel, R-I-E-L, and it's a 2000 California Supreme Court decision, 22 Cal 4th at 1150 or 1153, and the particular pages are 1215 through 1218. It was a very long opinion, but those pages really talk about this issue, and you start with the proposition that an attorney owes no duty to offer on his client's behalf testimony which is untrue, and the significance there is do you know as the lawyer that the testimony is false, or do you have some suspicion that it's false but you really don't have any proof? If you know it's false and you have proof of that, whether it's through other documents or whatnot, or your client's own statements, then you as the lawyer cannot ethically elicit that testimony from the client. Now, on the flip side, if you have some suspicion that the client's not being truthful, but you really don't have any proof, it's just the hairs in the back of your neck are sticking up, in that situation, you can ethically put forward the testimony of the client, even if you don't believe it to be true, but you just don't have any proof of it. And that's the fine line you have to run, because in this situation, the likelihood of you being able to withdraw at that point is very slim. I mean, you have the option of trying to withdraw, give the court as much information as you can, staying with the confines of Rule 1.6 and maintaining confidentiality, enough information so the court can even ascertain whether withdrawal is appropriate. But then you have to deal with the prejudice. And if you don't get, if you run up on a 5-year statute, you're not going to get out. If the other side's not willing to continue the trial, or the judge, given his or her docket, is not going to continue the trial, you're stuck. In that situation, your only alternative really is to, and they do this in criminal cases, because the defendant's right to testify if he or she chooses, you allow the client to testify vis-a-vis a narrative. You don't elicit any questions or testimony. You simply allow the client to testify in a narrative form. Now, opposing counsel may figure out, if you do that, well, something's amiss there. I suspect there's a problem there. Maybe that's testimony that is either not truthful or otherwise impeachable, but you really don't have an option as the lawyer for that particular client. And in a civil case, it might not signal that so much, because you don't have the right to. You can not testify if you don't want to in a civil case, assuming the other side doesn't call you under Evidence Code 776. But you really are in a pickle as the lawyer in that situation, because you're most likely not going to get to withdraw from the case. Now, fortunately for Attorney Kane in that particular case, the matter settled fairly quickly. And so he didn't have to run into that dilemma of having to put his client on, because the flip side of doing the narrative is that you then can't come back and rehabilitate your client to elicit testimony that would again be contrary or perjurious. It gives the opposing counsel a field day to cross-examine that witness, in which you can't do anything about.
Yes, that's one of your other options in dealing with a difficult client, is to be creative and come up with a solution that avoids having the client testify or dealing with the situation. You can always settle the case and lobby the client to settle the case.
Well, that's what I was going to say is you need to make sure to have that conversation with the client. Once you've seen the tape and the client's walking just fine. And so of course, by then I guess you would say, if you're Kane, you see what your client doing. She's not blind, or she's not appearing to have disability of sight. And you have to then remediate with her and go through the concerns under the candor to the tribunal rules, right? And so that you're not going to be able to put her on to have her testify because that what she was claiming is false based on what the totality of the circumstances that are now before you. But if you're Kane and she still insists on giving this narrative testimony, you're stuck in the litigation for whatever reason. You're stuck in the litigation. Then back to the earlier discussion, you're going to document that in your file, because you may not have a colleague that's going to be accommodating of that and understand. We've all had clients that we at least suspected weren't being truthful to us, or in some, maybe it was in a deposition or some instance, and we're kind of sweating it out to make certain that we're not violating any ethics rules. We can't make them do what they should do. And so we have to protect ourselves as lawyers in those instances, because if you don't have an accommodating opposing counsel, like in this hypo, Bill, who understood what the backstory was, and you have a counsel who's going to file, I'm back to the bar complaint. But again, I'm cynical after so many years in the regulatory side of things. Then you're going to have to deal with that. You've got your difficult client, and then you've got the difficult situation that the client dropped in your lap.
Right.
And so you're back to having the fallout yourself as counsel for this particular, this deceptive client.
I do see that there is a question. Julie, do we want to answer it now, or do we want to wait? I'm happy to address it now. If
I think we should address it.
Yeah. So the question was really, what if the attorney is for a governmental agency? As you see on the screen there. Now, there are some nuances with the rules as it deals with prosecutors and whatnot. However, I don't think for purposes of these situations, or whether you're a governmental agency, your client, let's say you are Department of Consumer Affairs lawyer, and maybe one of your employees is you talk to an employee, and that employee may be offering perjured testimony, or going to offer perjured testimony. Your client is not the employee. Your client is the agency, first and foremost. But the situation is no different. You because that person may be a representative of the agency in a situation that would implicate liability to the agency, you would have to go through the same process of counseling that individual to obviously not offer perjured testimony, and the consequences therefore. If for this person does not want to listen to you, that's a situation where you have to bring it again to the attention of the court. You have to withdraw. Well, I don't know if you can withdraw. It really depend on the situations. If it's just a witness, maybe in a deposition, you wouldn't have to withdraw. You may just say, I can't defend you in the deposition. What do you think, Dan?
Well, if you're employed by the client, same for in-house counsel in a private company. We're a governmental lawyer. Your client is also your employer. The withdrawal is a heavier burden, because it means you would basically not be doing your job and either quitting or subjecting yourself to potential termination for refusing to do your job. But I agree with you, Bill, that for the governmental attorney, your client is the agency, the governmental agency as an entity acting through its highest authorized person. And if there's misconduct by a witness or subordinate personnel within the agency, you report up to your client representative. If your client representative, the elected official who's running the department, or otherwise is the client decision maker, is misbehaving in a way that you believe is inappropriate. You got the duty to maintain confidentiality in a governmental setting. You can still report up within the government to the attorney general or whoever your superiors are. But if nobody's taking action and you believe it is, you're being asked to do something that's criminal or fraudulent or, truly against the rules, you're as a lawyer, your ethical remedy is to withdraw. And if that means, refusing to do your job and being subjected to being terminated, that would be the consequence. As pointed out in the comments, there are whistleblower protections for California public employees that could be invoked in that situation. But in terms of the ethical rules governing your conduct as a lawyer, it's the withdrawal is the only remedy. In that, if the client at the client top level was really doing something wrong.
I had that instance. It wasn't quite this, but I had a witness when I was an assistant attorney general for about 10 years before I was in this office. And I had my primary witness, my primary client witness to prove the case. And I was prosecuting the case, started lying. I mean, I had seen, I had all the documentation, I had the investigation, and what she was testifying to on the second day of trial was contradicted by the documents that I had already been in receipt of from her. And so we took a recess and I talked to her, and she insisted that this was true and that I was mistaken. And, I'm flipping through my file and saying, I'm seeing it right here. This is your notes to me. I put her back on thinking that she would retract her testimony and fix it. She didn't. And so I looked at the judge, and I'll never forget the judge's look when this particular judge is now on our Supreme Court. And I said, Your Honor, permission to treat this witness as a hostile witness. And I had to go through it because I wasn't, especially as in the position I was in, wasn't going to allow her to give false testimony to the court when I knew it was not true. And then I reported her to the agency and she was fired. But, there was a couple of different things there that you had to do. And thankfully she didn't, she wasn't somebody that was far enough up that she could have blocked the objective of the representation, which was to ensure that essentially justice was served. But had she been the head of the agency, then under our rules, I would have been able to, at the very end, contact law enforcement.
In the few remaining minutes, I want to make sure that we cover the diminished client topic. And so, Aria, if you want to speak on that.
Sure. So, I gave a hypothetical, but before we don't really need to get into Derek as much as I want to make sure that y'all are aware of the California. I'm just pulling it up here. That the opinion that you gave us, Dan, and I just marked it up and now I've lost it because I'm just on a laptop. Here we go. Opinion number 21027 of your ethics opinions is the California Standing Committee on Professional Responsibility. I love this opinion. It's great. It gives you different scenarios, but essentially under the diminished capacity rule, and for those of y'all who've run into these kinds of clients, you might have diminished capacity clients because the clients are using or abusing substances. They might have traumatic brain injuries. They might be incapacitated by cognitive issues arising out of their age or mental health status. But the precepts of this dilemma for a lawyer is that, number one, you have to make sure to treat the client insofar as practical in a normal attorney-client way. And so you want to make sure that you're providing competent representation in a manner that is tailored to this particular client's needs. that, again, you're communicating with the diminished or potentially diminished capacitated client in a way that also is tailored to their needs, that you provide loyal representation in a non-discriminatory fashion, so that you don't make assumptions about the person who's sitting before you that might have a traumatic brain injury, and that you don't substitute your judgment for their judgment, because you still have this agency relationship. You may be able to take protective action on behalf of a client with diminished capacity, and you may be able to seek advance consent when the client has competence, particularly, and I think that can be particularly effective for a client who is aware that she may later lose some competence. And so it's permissible for lawyers to request that advance consent when the lawyer is certain that the client has the capacity to give the advanced consent. And so in this ethics opinion, thank you again, Dan, for providing that to us. It gives you various scenarios. And in the first scenario, it's a little bit like my Derek hypothetical. And of course, I wanted to make Derek old enough so he's not a minor. But for those of you who do PI work, these are the kinds of clients you may have had. And it mixes this scenario that you may have run into, which is you might have perhaps not an interfering family member, but a family member who cares. And it may be eventually that you have to rely on that family member as an agent for the client. And so this opinion goes through different scenarios. And I think it's important for y'all who do not have the model rule in California. We have a version of the model rule here in Maine, and many states do have Rule 1.14. But you have a lot of the concepts, and this opinion lays them out very well and gives you different reasons why in scenario one, the lawyer can, for instance, defend the client against a conservatorship. And in that instance, for clients who are opposing guardianships or conservatorships, so long as the client in that instance understands and can make some of the decisions, that's what the lawyer needs to default to and make sure under the duty of loyalty that the lawyer is pursuing to try to advance the client's goals. The lawyer may not prevail on behalf of the client, but you may be in a situation with a client who has enough capacity that you should still follow their directives in the representation. But for many of you who practice in the estate planning bar, I can't even tell you how many times I've talked to lawyers who have had clients and they've been subjected to undue influence. All of a sudden there's a new best friend, there's a family member, and the lawyer who's, if this has been Bill's client for 25 years and all of a sudden the estate plan is totally changing, it does not make any sense under your rules or our rules that Bill would change the client's estate plan. The unfortunate part is the client could go, the nephew could bring the incapacitated client to some new lawyer who doesn't care and has no relationship and is more than happy to follow the directives of the person seeking to have the estate plan changed, which is really, the new best friend or the family member. So there's a lot of pitfalls out there. Excuse me. I'm choking, of course, when it's my turn to talk. This is my second presentation today, and so I'm a little hoarse already. But there are a lot of pitfalls when trying to assist an incapacitated client. And I'm going to have one of y'all jump in so I can take a drink of water.
One aspect of one tool you suggested, Aria, was getting the client's advance consent to certain actions, and that's certainly appropriate. There are some pitfalls around that. in certain areas. There was a case within the last year where a lawyer had gotten, it wasn't a diminished capacity case, but a contingency fee case where the lawyer had gotten the client's advance consent to settle the case for a reasonable amount in the lawyer's, judgment and discretion. And the lawyer entered a settlement. The client didn't like it and sought to avoid it. And the Court of Appeal held that it was a violation of the rules of professional conduct for the lawyer to get advance client consent to settlement, that the client always has to have the settlement decision-making authority, and it's not something that could be given up in advance. There are also issues around advance waivers of conflicts
Sure.
that have to be evaluated at the time the conflict arises. So there are some pitfalls around those things, but when you have someone who is diminished or may be headed that way, planning in advance for who's going to have decision-making authority, or if you are going to need a conservatorship, power of attorney, those kinds of things, as much advanced planning as possible is going to be beneficial to everyone.
Absolutely. And just to lay that out in the beginning, and good, the good estate planning lawyers that I've worked with and have known, they do that. They literally have a checklist that they'll go through with their clients, and it leaves nothing, or at least very little, to chance. Bill, were you going to say something?
Oh, I was just saying, you have under the probate code, if you're doing, some estate planning work, I mean, you can always go and petition the probate court for a certificate of independent review, where you've had another lawyer look at it. I mean, you don't have to petition the court for that, but you can get certificate of independent review from another lawyer to confirm that everything you said is done is correct and consistent with the client's objectives. I mean, you always have the benefit, certainly in the estate planning context, to petition the probate court to confirm, basically bless everything you've done on behalf of the client. So, if you get down the road and the client has a change of heart and say, oh, that's not what I wanted, well, you have at least a court order saying, yeah, it's okay. So there's some protection for you as the lawyer. But again, you want to document everything. This is, again, a document everything in writing. So if there's a question down the road, you have a trail showing the advice given, the response, and that information will protect you down the road in the event that you are a target of discipline or a malpractice suit.
Some additional things when you do document those things in response to Sophia's question there, you can add language saying that the course recommended by the attorney and agreed to by the client is not mandatory. It's the client's decision. The client's had the opportunity to consult with independent counsel and has had the opportunity to ask all questions that they have, and just thoroughly document that the client has provided informed consent, because that will be the standard by which the client's decisions are evaluated. Did the client have adequate information to provide fully informed consent? And that can be achieved through documentation.
I think in a situation, if I'm understanding Sophia's question correctly, the steps, and it's much easier in a situation where you have, and I purposely did this, you have somebody with an obvious attachment and generally good relationship. So you have this grandson with his grandmother, and if Derek were my client, I would, as soon as I noticed that he had some cognitive issues, or I was concerned that I might have difficulty with getting him to be responsive, whether that's because of his marijuana use, because of his brain injury, or because he's just kind of in and out, I would be wanting to know, can I rely on your grandmother to help me make decisions for you? I would just be straight up with him to let him know that this is what I need from him. It's back to the managing expectations. If you've brought your grandmother here, she she's either in the scope of this representation or not. I left that vague, obviously. And in fact, generally, she would not be somebody that you'd share confidential information with. But under the jurisdictions who have adopted Rule 114, it does allow you to loop somebody in that the client trusts. California, I want to be careful about saying that y'all can do that unless at a time where the lawyer is certain that Derek has capacity to say, yes, if I'm having a bad time or, I've taken off and gone for a few months with my friends. If you have to make decisions about the litigation, you can talk to my grandmother. I just don't want her to decide the number, Dan. The number's decided by me. And so then Dan's message back to Derek is going to be, well, Derek, then you better always let me have your cell phone number. If you're changing numbers all the time, because I can't settle this case unless I get the number from you. So.
All right, I think that wraps up the questions that we have. Thank you guys for going over a little bit, and big thanks to Dan, who his internet must have had an issue. Aria, and Bill. Oh, there's Dan.
There's Dan.
Big thanks to all of you guys for spending so much time and preparing for this. And thank you for everyone who joined us today. And for those of you who have been with us through this mini marathon series, you finally made it to the end. And if you're not an AABA member, we hope you consider joining AABA for more excellent programming. So thank you very much.
Thanks for having us.
Thanks for having us.
Yeah.
Bye.
Bye.
Bye-bye.